So first we need to know what serious illness is. Anyone know what that definition is? Yeah, in the back.
I imagine it would be life-threatening.
Good answer in any state other than Massachusetts, and fortunately a good answer in any state other than Massachusetts. So most states that have a serious illness rule, it has to be life-threatening or gravely serious or God knows what, something on that end of the spectrum. In Massachusetts, it's anything a doctor says is a serious illness. So I want to make several points around this. This is a very important concept because your instincts are right. Fortunately, we have a much better rule in Massachusetts. And the reason you need to know it is a doctor's probably going to reach the same conclusion unless you educate the doctor. Oh, I can only sign a letter if the person's going to die. No, it's anything the doctor thinks is a serious illness. Physical illnesses, mental illnesses, emotional illnesses, disabilities that you might think of not as an illness. You're in a wheelchair, or you're blind, or you're deaf. Some people might say, well, it's not an illness. People live with those things their whole lives. I'll give you a couple. ADHD, attention deficit disorder works, asthma works. Anything the doctor says is a serious illness is a serious illness. I'll get back to how true that is because the regulation says so. The example I always use is when I first started doing these trainings, I don't suggest this at all, but it seemed that all people were doing was giving out my phone number to everybody they knew after the training. The goal is to make you better advocates, not for me to get 1,000 phone calls. But anyway, this woman calls, and I actually do tend to take most of those calls. And this woman calls up. I forget why it moved me so much, but I was really moved, and I kept saying, you sure there's not a serious illness in the household? It was the mom and her 21-year-old son. She kept saying, no. Day 3, I'm still working on this one, trying to solve it. I say, you sure there's not a serious illness? She says, my son just got home from the hospital. And before you think, well, why didn't she say that on day 1? Her son was a 20-year-old football player who'd broken his leg. And the doctor said that that was a serious illness. So your role and the doctor's role is not to exclude anything because you think it has to be life-threatening or you think you have to defend this in some public forum somewhere. God bless, our legislature said if you're poor and you're sick, you don't lose your utilities. They didn't say if you're poor and about to die, we protect your utilities. So you need to educate the people who sign these letters, and I'll explain who signs the letters. And here I do want to emphasize that I really do mean that anything the doctor signs is good because there's a reg that says so. So if you turn to page 70 in the book, there's a bold heading called Conclusive Effective Certificates. And it says certification of serious illness and infancy shall be conclusive evidence of the existence of the condition claimed unless otherwise determined by the department after investigation. Now, I know that's a bit of legalese, but it says if the doctor sends in a letter, the company has to assume there's a serious illness unless the company goes to the department and there's an investigation of that letter and the department says, oops, that's not a serious illness. It's never happened. Doctor's letter is good. So any company that would reject a letter, and a few years ago, we did see this pattern. Again, once again, the consumer division got involved. If you see a company rejecting a serious illness letter, no, there's only a couple of grounds that you could reject a serious illness letter. It's not signed by the right person, which is a doctor, nurse practitioner, or physician's assistant. You know, something I sometimes forget to stress, can be anybody in the household. So it could be my kid or some other relative or anyone else who's in my household. It doesn't have to be a person who's legally in the household. So we all know in public housing they have this formal list. I don't care whether the landlord knows that person's there. If they're really in the household, the serious illness rule applies. So another reason the letter could be rejected is there's nothing in the letter that says where that doctor's patient lives. So the letter should include the address because it could be someone whose name is not on the bill. How does the company know that person's at the address? Okay, so serious illness can be anything mental, physical, emotional that the doctor says. Folks at Boston Medical Center were in a docket with my office about a year ago, and we stressed that, well, sometimes the doctor can't sign the letter, so they did broaden it. It's doctor, physician's assistant, nurse practitioner. Sometimes the practice is better than the rule says, not only here but in other areas. So this is one area where the practice is often better, or sometimes better. Lots of many people with emotional or mental illnesses aren't seeing their primary care doctor. They're seeing a psychologist or a licensed clinical social worker. Sometimes a letter from that person will work because the company gets it. Oh, right, your doctor's not the one who actually sees you for that condition. But if you read the reg, technically you have to get the doctor's signature. But sometimes it will work. So it's, if you can't get the doctor to sign the letter, but there's some other professional that looks like they would know the condition, try it and see what happens. I haven't had great luck, strangely enough, at the consumer division, but sometimes the companies will get that makes sense. Okay, so I mentioned that it can be anybody in the household. That's really important. It can be absolutely anybody in the household of any age can have that illness, and you get the protection. So let's get to the letters. There are sample letters in the book, and they start on page 87 and flip on to page 88. There's legally two kinds of letters. There's two legal categories of letter: a chronic letter and what we could call a non-chronic letter. So if you have a chronic illness and the doctor uses the magic word chronic, make sure the doctor puts the word chronic in the letter. That letter is good for 6 months, so you'd only have to get 2 letters a year signed. If the word chronic isn't in the letter, even if it looks like it's a chronic illness, the company can insist on getting a letter every 90 days. This is another area where the rules got a lot better. Again, people at Boston Medical Center pushed hard on this because their practice has to crank out literally thousands of letters a year. It used to be a much shorter time, 30 days for the non-chronic letter, 90 for the chronic. But now the chronic letter is good for 6 months. In some instances, I've seen companies not insist on follow-up letters when it's really clear that condition's never going to go away. They may not insist. So again, practice is better than the law requires. If they want to, I don't care what the letter says, how clear it is that person's going to have the illness for the rest of their life, they can ask you to do it every 6 months. Okay? Any questions on the letters? A few other things I want to say about the letters. Some companies will say, wait till we send you a form. Why wouldn't you want to do that? You're losing time. Who knows if they're really going to send it? And even if they do, you're losing days. And this can stop at termination. So you don't want to wait until your client's terminated and then fight to get their service on. Also, you don't have to use the company's form at all. There is no required form. And so this is a good place to make a broader point about utility forms. So I'm not an expert in food stamps, but I think I know this to be true. If you're applying, I guess it's called SNAP now. If you're applying, there's a form, and the state develops the form. Therefore, it is the form. You can't use anything else, right? You know that. With most of this utility stuff, there is not a required form. So don't think you have to use something the company says it's going to send you. And sometimes the forms are not in compliance with the regulations. So if you turn to page 89, and then the pages aren't numbered because these are PDF files we printed, but if you turn to the page that would be 91, it says Financial Hardship, Other Protection Certification Request Form. This is the form of New England Gas Company, and in the print below the dashed lines it says, please complete the doctor certification form which requires your doctor to certify and or provide a description of the handicap medical condition. New England Gas reserves the right to contact your doctor to confirm this information. Well, first of all, they're implying that you have to use this form, no. And second of all, I'm on page 91. There's 2 forms. One is elderly, and one is financial hardship. And I was reading the words underneath the dotted line. So the last dotted line says number of people in household. And right under that it says, please complete the doctor certification form. I don't think it's particular. Oh.
I can see, but not well.
Yeah, I can see, but not well either, but I've done this enough that I know where to look. And then I take my glasses. Yeah. So I don't think it's legal for the company to contact the doctor. Anyone know why? I kind of tipped this off a few minutes ago. What?
You're protected on the HIPAA laws also. They can't just disclose.
Well, if there's HIPAA issues, they might be violating. And remember it said if the company wants to challenge it, they have to go to the department. So they can't reject the letter. There's no reason to be calling your doctor. They may be violating your privacy. I think the form's illegal. There's a couple of other things I won't mention that I think is illegal about the form. I was in a hearing, and I forget why, but companies' forms were submitted in the case, And I got up and said, excuse me, but I think New England Gas's form is illegal, doesn't comply with current law. You will never guess what the lawyer said. He said, we know that, we just printed 1 million of them, so we're going to use them until they're used up.